House Concurrent Resolution 5008, proposing a constitutional amendment to provide for legislative oversight of rules and regulations adopted by executive branch agencies and officials. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Concurrent Resolution 5008 provides for the revision or revocation of administrative rules and regulations. This is another piece of legislation that was pretty heavily amended in the House, so I'm not going to talk about the House changes, but I can, of course, answer any questions about those. As currently drafted, the resolution, if it were to be approved by the electors, would add a new section to Article 2 of the Constitution to provide that the people's duly elected or appointed representatives and senators may revise or revoke administrative rules and regulations or any portion thereof by adoption of a concurrent resolution. Concurrent resolutions that propose amendments to the Constitution, as you all know, must be adopted by a 2/3 vote in each chamber, and then they are presented to the general electorate for approval. If that process were to happen, then this would be submitted to the electors at a special election on August 4th of 2026 to be held in conjunction with the primary. And I can take any questions.
Thank you. Committee, any questions? Senator Corson.
Thank you, Madam Chair. And I know that there are differences, but I know that we had a similar in theme constitutional amendment on, I think it was in August 2022. Would you be in a position to just kind of talk to us about what that was and what this is and how they're different? I know that, I'm sure that they are, but if you could help explain what those differences are. Thank you.
Madam Chair, Senator Corson, I should have brought that with me. That would have been a good way to prepare. I would have to look at the language of that to be able to do that comparison, but I'm happy to do that once I sit down after you guys take the testimony.
Yeah, that's no problem. If you maybe just send an email that we could maybe get around to folks. I'd just be curious kind of what a side-by-side would look like. Thank you.
Thank you. Committee, other questions? Not seeing any, then thank you very much. We will hear from our first proponent conferee, Eric Stafford, Vice President, Government Affairs, Kansas Chamber. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Eric Stafford with the Kansas Chamber, and I do appreciate the opportunity to be here today in support of HCR 5008. Apologies, I got thrown off with Senator Corson's question. I think the short answer is not the first time. So I think the short answer, I think the original version pre-amendment in House committee was very closely aligned with the 2022 amendment. This one's shorter and I think intended to be a little more clear. Basically, the people's duly elected or appointed representatives and senators may revise or revoke administrative rules and regulations or a portion thereof. So the language is just much shorter than what it was before, but the purpose is still the same. We've been before the legislature dealing with rules and regs for several years, dating back to 2018, when the legislature passed and Governor Collier then signed the economic impact statement requirement that we had gotten really from Florida, Wisconsin, and other states, and then followed up last year with the REINS Act that if a regulation costs more than $1 million over the first 5 years of implementation, that has to go through the bill process in order to be approved by the legislature. So really our intention here, in our view, from our viewpoint, in support of this constitutional amendment, same as it was in 2022, it was the most narrow of the constitutional amendments that were up back then. This one lost by, if I recall, 8,000 votes, roughly 8,200 votes, so it was very, very close. But from our perspective and our intention is really to ensure that the executive branch does not go above and beyond legislative intent, no matter what ideology or administration is in place in the governor's office. And you can pick the issue. You can pick a social issue, you can pick a labor issue, that if a governor issues an executive order that goes above and beyond, or an agency excuse me, issues rule and regulations that go above and beyond legislative intent, this provides a strong check and balance from the legislature to prevent that from happening. So we do have the economic impact oversight perspective from the legislative perspective when I mentioned the REINS Act, but we're one of a few states, I think 10 states or so, 12 states or so, that do not have legislative oversight of rules and regulations. So this constitutional amendment would put that in place. But for example, there were several regulations being proposed that got to JCAR several years ago that we came in November of 2021, I believe it was, to testify in opposition, that 3 of the 7 proposed regulations that they were offering were in direct conflict with workers' compensation laws. One of them was changing the formula of how you calculate wages. So thankfully we were able to get those stopped. Some of the other ones were notice requirements from carriers, right? That is a regulatory act. That is the department saying, hey, insurance carriers in the space of workers' compensation, we need these notice requirements to be sent to injured workers within a certain time frame. Fine. Changing the formula of how you calculate wages has massive implications in workers' compensation, and that should not be a rule and reg process. If you want that done, go through the legislature. The same thing could be said a couple years ago when Department of Transportation came up with the regulation dealing with 2-person crew requirements for railroads. That is a policy bill that labor unions had been pushing for that could not pass the legislature. I don't know how an agency would have the authority to establish that type of policy. So in our view, it can go both ways. I think that there are some, there was a fury of President Trump's executive orders over the last couple of weeks, his first month in office. And tax policy is my motivating issue as a voter. Close in number 2 is executive power. And I don't care what president's sitting in office. I have a hard time seeing so many executive orders signed that if it's a policy position, it should go through Congress or it should go through the legislature to go into effect. So in our view, this provides the proper checks and balances between the legislative branch and the executive branch. And it was very close back in 2022 when there was a whole vote no on everything campaign, and unfortunately we lost it. But this version, again, we feel it's much shorter, much cleaner, but would still have the same intent as what the one in 2022 did. So be happy to answer any questions at the appropriate time from the committee, Madam Chair, but we do appreciate the opportunity to speak in support of this constitutional amendment today.
Thank you. And we do have a follow-up answer to Senator Corson's question from the reviser. And if you'll be able to stand for questions at the appropriate time when we're done with conferee testimony. Thank you. Go ahead, Ms. Scott.
Thank you, Madam Chair. The language that was in House Concurrent Resolution 5014, it's also pretty short, so I'll just read it to you. Whenever the legislature by law has authorized any officer or agency within the executive branch of government to adopt rules and regulations that have the force and effect of law, the legislature may provide by law for the revocation or suspension of any such rule and regulation or any portion thereof upon a vote of a majority of the members then elected, appointed, and qualified. So what I would say that the big differences are is this one, the one that was proposed in 2022 really only speaks to revocation. It doesn't speak to revision. And then that one did not specify the adoption of concurrent resolution, how you would take that action, whereas this one allows for revision of those and then specifies that you would do that by the adoption of a concurrent resolution.
Would the adoption of a concurrent resolution require 2/3 of a vote in each chamber?
Madam Chair, it's interesting that the one that was put forth in 2022 specifically says a majority. This one is silent on that. So my interpretation would be that it would just be a normal concurrent resolution that just requires a majority vote.
Very good. Thank you. We will next hear from Amy Sipple, ARNP, FNP, and GS-C. So please introduce yourself and welcome to committee.
Amy Seipel. Thank you, Madam Chair and committee members. I come today in support of HCR 5008. As a nurse and nurse practitioner, I have experienced the draconian rules and regulations of the Kansas State Board of Nursing that threaten my professional future. For over 3 decades, I have served the needs of citizens in our great state. It has been a joy and an honor to walk with people during some of the most vulnerable and desperate states of their existence. I care for the underserved in long-term care facilities, and I've accompanied nursing students on their academic journey towards nursing excellence in the university setting. In all of this time, in over almost 33 years, I have never been sued. I have never had any complaints filed against me. Last spring, my husband of 33 years was diagnosed with metastatic cancer. I was terrified and devastated. I had taken a step back from practice and just focused on living this journey with him. After his surgery and stabilization, I was ready to go back to work. I got on the State Board of Nursing's website, and much to my dismay, I saw that my license had expired 4.5 months earlier. Now, in 32 years, I have never been late renewing my license. Now, for nurses and nurse practitioners, in order to renew your license in the state of Kansas, you have to meet 3 criteria. You have to be current on your malpractice insurance and your continuing education hours, and you have to pay the dues. Now, fortunately for me, I always have way more education than I need, and all of my hours were current prior to the expiration deadline, and I've never let my malpractice insurance expire. I submitted evidence of this, and I paid my dues, and I expected to pay a fine, a late fee. I did not anticipate the discipline that was coming my way. I have been asked to sign a consent order that will label me with unprofessional conduct for practicing without a license in perpetuity. This is in spite of the fact that you will find no billing under my NPI number during this time that I was serving the needs of my husband. The State Board of Nursing tells me they plan to put my name on 3 separate databases forever. Even after I die, it will still be there, listed as unprofessional conduct. Now, the worst insult that you can give a nurse, there's 2. One is incompetence, one is unprofessional. But unprofessional is by far the worst because that impugns my character. How do I take care of vulnerable people if you cannot trust me and you call me unprofessional? That is untenable to me. Now, and they're also going to put it on their newsletter and send it out so all my former nursing students can read this as well. Now, if I do not sign their consent agreement, I have been warned that additional sanctions can be brought against my license. I've been warned strongly several times on that, in fact. Now, if I go to hearing, this is not in front of the Board of Nursing. In fact, this is all staffers that I've been working with. If I go to hearing, this is in front of a single hearing officer who's not even a nurse. This is an attorney who works with the Board of Nursing. How fair is this? Now, prior to this experience, I was highly employable. And I don't say this to boast, but I'm just letting you know my background. I was the former president of the Kansas Advanced Practice Nurses Association. Governor Collier appointed me to serve on the very first Alzheimer's Disease Task Force for the state of Kansas. Governor Kelly appointed me to serve on the board of Adult Care Home Executives, where I am the chair. I have been awarded the AANP State Award for Excellence. I was the Professor of the Year at my university. And other things. God has just blessed me with leadership positions. But I tell you this because none of that matters now. I am highly unemployable now. I have been turned down by organizations one of which said, we don't employ nurses who are going through the disciplinary process, and another one said, by policy, we prefer not to employ nurses who have been designated as unprofessional. And I get that. Prior to this experience, I never would have employed a nurse who was labeled unprofessional by the state of Kansas. And let me tell you what unprofessional means. If you look at the categories, you can be labeled unprofessional if you sexually assault a patient, if you physically abuse a patient, if you take their narcotics or steal from them. It's all the same. And some of you may have heard about Elaine Gebhardt, who the State Board of Nursing did not like her social media post. And so they attempted to label her as unprofessional as well. I implore you to please pass HCR 5008. I don't know what other hope we have, and I don't know that you will be able to help me. And let me say just one more thing, too. I had aspirations to run for political office. I went to the State Board of Nursing and said, there's no way I can run for political office. Imagine what my opponent would do. It would be on every palm card they had, listing me as unprofessional. I asked the State Board, I said, if I will just resign my license and leave nursing, will you withdraw this case so I can at least run for political office? And they said no. They are pursuing me anyway. I ask you to pass this. Please, on behalf of all the licensed professionals out there, we need your oversight over boards like this. Thank you, and I stand for questions.
Thank you. Are there any other persons wishing to testify as proponent on the resolution? Yes, please identify yourself and welcome to committee.
Thank you, Chair Warren. My name is Jim Manley. I'm the State Policy Chief for Pacific Legal Foundation. We had an opportunity to speak recently, so I won't go through my entire introduction, but I will say that one of the areas that Pacific Legal Foundation litigates and helps with policy on is separation of powers. We think it's a core issue that faces our nation. And Kansas has already made great strides in reining in the administrative state and ensuring legislative accountability for rulemaking in passing HB 2648, the REINS Act, last session. The REINS Act that Kansas passed, however, only allows the legislature to approve new rules. And of course, this amendment would look back to allow the legislature to assess if rules that have already been put into place are being administered in a way that is consistent with the legislative intent when the legislature passed the law and gave those agencies the authority to enact those rules. The expansion of HB 2648 to include rules that are already in place will help enhance the separation of powers, ensure that the legislative function remains with the legislature, and that agencies do not have the ungranted authority to legislate on matters of policy that should rightfully belong with the legislature. I think I won't repeat what has been said by other conferees. I think they handled the issue quite well. But I'm happy to answer any questions.
Thank you. Thank you. Will you go ahead and submit written testimony then as well?
Be glad to. Thank you.
Thank you. Are there any other persons wishing to testify as proponents on the resolution? Yes, please introduce yourself and welcome to committee.
Thank you, Madam Chair. On behalf of Randy Stuckey this morning, on behalf of a few association, we have submitted written proponent testimony, but on behalf of the Kansas Grain and Feed Association, that's the grain elevators in the state of Kansas, Renew Kansas Biofuels Association, that's your ethanol and biodiesel plants in the state of Kansas, and Kansas Agribusiness Retailers Association, just like it sounds, we sell goods and services to Kansas farmers. All highly regulated industries by both the federal and state regulators. Did submit written testimony. We'll draw your attention to that. I didn't think I could be here this morning with other things going on, but just want to make sure that you understand that as a highly regulated industry, we've stood with the Kansas Chamber and other proponents on other bills that would seek to rebalance this issue of agency regulations, giving those that have the constitutional authority to make laws, and let's be clear, rules, regulations have the force and effect of law. For that reason, we want to make sure that we can reshift that authority, that statute, the constitutional and statutory authority, back to this body to have at least some teeth to say that, okay, this regulation that is being proposed by X or Y agency has gone too far. You've exceeded the delegated authority in this statute. You don't have that today outside of passing a full bill that then has to be signed into law by the executive branch who's proposing the very regulation that you're seeking to overturn. It's pretty clear to us we're out of balance. This is a larger conversation than just Kansas, but this is where we stand on the issue. For that matter, for that reason, we'd ask you to please support this bill and give it back to the voters to make that decision. I know we've already sent this out once, but it was, we think, caught up with some other constitutional amendments that were proposed at the time. This should be given a new, clear look on its own to the voters. And for that reason, we'd stand in support of the measure this morning. We'd clearly stand for any questions, but wanted to make sure we had the opportunity to speak this morning. And thank you for that opportunity.
Thank you. Before we open it up for questions, are there any other persons wishing to testify as proponent on the resolution? Not seeing any. Then committee want to also direct your attention to a testimony at your desk, proponent testimony from Shahira Stafford, Stafford Public Affairs, Kelly Van Zwal, Vice President, Government Relations, Kansas Bankers Association, Jason Watkins, Wichita Regional Chamber of Commerce, Randy Stuckey, General Counsel and SVP Government Affairs, Kansas Grain and Feed Association, Kansas Agribusiness Retailers Association, Renew Kansas Biofuels Association, Andrew Weens on behalf of Opportunity Solutions Project, Carrie Sue Vosberg, private citizen, and Brett Anderson, private citizen. And with that, then we'll open it up for any questions. Yes, Senator Reichman.
Thank you very much, Madam Chair. And I'd like to ask Amy Sipple, or how you pronounce your name, a question.
Yes, sir.
Thank you very much for testifying today. Very intrigued by your presentation and your story, and I thought you did a great job. I have two questions. One, why in the world do you think that they came out and used unprofessional conduct to you? What was their rationale behind it? And number two, how would us passing this HCR 5008 help your position? Thank you.
Great questions. Thank you so much for asking them. So it's hard for me to speculate exactly all of the rationale behind this, but the unprofessional conduct is a catch-all phrase that they use for just about anything, any reason they want to come after a nurse. And I'm sure it's a pretty strong revenue stream instead, you know, to do that kind of all-encompassing. And people are very in tune to just sign that consent agreement. If you change the designation, I admit I should pay a late fee. I was late paying my dues. I should pay a late fee. But if you change that designation from unprofessional conduct, and I'd have to get my notes. I can't remember what, but I can tell you which regulation it is. Just a minute. So KAR 60-3-110 is the unprofessional conduct. So looking at that, there's another one too, 65-1113. This is where, so even though I wasn't seeing, I was never paid for seeing patients during this time. I volunteered for family. I sat with people who were dying. But they found on my website that I was speaking. I spoke. I would try to educate and equip caregivers of people who have dementia is the primary thing I did. I'd go to senior centers. I'd volunteer. I did speak at conferences as well. But they said that I did not have I was no longer qualified to speak to people about matters of disease and illness. I didn't have a brain dump when I failed to renew my license, and I'm helping people. And a lot of it is just gratuitous. So if you would look at just those two, change so that they couldn't come after me for that. And I would love to see a diversion. If you could create a diversion process so that it's not in perpetuity, I don't have to carry a red scarlet letter around with me the rest of my entire life. I'm sorry. Does that answer your question?
Well, impartial, I don't agree with the reason, I agree with what you had to say, but I don't quite understand how passing this is going to help your case. I wasn't quite got the connection. Thank you.
Well, I guess I don't know if the legislature has an ability to encourage diversion. That would be ultimately what I would love to see. So I don't think you'll help me, but maybe you can prevent the Board of Nursing from eating their young in the future.
Thank you. Other questions? I have a question for maybe it's Randy, if he would, Mr. Stuckey. So you mentioned often for our highly regulated industries, and we've heard some personal testimony today about how some of that has impacted personal lives of Kansans. Would the industries you're here on behalf of, they would find it helpful that instead of having the boards, the agencies kind of combining the branches of government, the executive and the legislative branch, because they're enacting regulations that have the force and effect of law without it having to go through the legislature and then be signed into law by the governor. Right now, we do have JCAR, the Joint Committee on Administrative Rules and Regs, but without 5008, that committee doesn't have any ability to amend or revoke any of the rules and regulations. And so 5008 would help with that.
Well, I think so. That's how I envision the process working. And as somebody who appears in front of the Joint Committee on Rules and Regulations or Administrative Rules and Regulations, JCAR, routinely, it's been frustrating throughout the years, and for those that serve on the committee, I'm sure, when they come to realize that they've just been presented a regulation that they disagree with for whatever reason, and they realize that the only thing that they have, the only recourse they have as the legislators, the folks that are appointed with the authority to pass laws in the state of Kansas, is to write a sternly worded letter back to the executive branch agency saying we don't like this regulation, and then we've seen it be passed anyway, adopted into law, unchanged. So the process, as we understand it, and we think would probably work out, is you would still utilize the JCAR, the Joint Committee on Rules and Regulations. That committee then would be able to receive the hearing on if it's a bill that was presented by somebody that asked for this on behalf of an industry or a regulated party. They would say, hey, look, the agency we believe has gone too far, and then it would just be a bill like any other that would redirect or override that regulation. And as we can work out the details, but that's the broad strokes of how this would play itself out. You'd actually utilize that committee for its intended purpose, I believe, not just for a superficial check in the box to say we've gone through the process.
Thank you. Yes, Senator Clays.
Thank you, Madam Chair. My question is actually for Amy Sipple, who was up here before.
Yes, sir.
If you can reintroduce yourself for the people at home.
Amy Seipel, yes.
Seipel, I'm sorry.
That's fine.
So I work in the schools, and in the schools, the licenses are, the responsibility, obviously, of the staff, the teachers, the psychologists, the counselors, and everything. But the administration supports that because they can't have somebody that's unlicensed working for them. So I'm trying to work my way through understanding what happened in your situation, because it seems like your employer would have to have known that you were unlicensed. What's going on with that?
Right, and that is typically the situation. I had stepped out of practice when my husband was diagnosed with metastatic cancer.
Okay.
And so I didn't have anyone reminding me at that point. And it is my responsibility. If I had a 2-year calendar, I would put it on my calendar. But again, it's the first time in 32 years I've missed it.
Yeah, if I can follow up. So, first of all, I'm very sympathetic and a bit frustrated, probably not as much as you with your situation. I find these kinds of situations just, I mean, you've got this benighted group of people that are making decisions that don't make any sense. And to me, you know, you've got somebody that's conflating, you know, paperwork with patient care. You know, obviously that's, you know, calling those the same kinds of egregious problem is difficult for me to understand why anyone would do that. It also dilutes the term, you know, unprofessional conduct when you use it for things like, you know, not getting a license that you're not using evidently renewed. I mean, that would be like using, you know, you didn't get your parking permit either, and so that's unprofessional conduct. And it is in a way, but it's not that. I parked in the wrong place recently, and I would hate for that to be on my record forever. But I am concerned that this requires a constitutional amendment, and I really hope that there's something else that can be done in your situation, because I can't believe that this is the solution. I'm all for this HCR 5008, but I'm shocked and surprised that this is the solution to your issue.
I don't know that you can, I don't know that I can be saved. And probably my testimony today is not going to make my life any easier.
Okay.
But maybe I can help other people. Now, I will tell you, if you look at that regulation under unprofessional conduct, they do differentiate like A, B, C, D, you know, W, I think W down there or something is practicing without a license, and then social media or something is down there, but it's all under the same heading. But the real problem, if you talk to any nurse, and nurses understand this, if you are labeled with unprofessional conduct, nobody's going to go back and look to try to figure out, was that an A, B, or W, or, you know, you just hear unprofessional conduct and you've got a red scarlet letter.
Well, at any rate, I hope you run for office. I think that you would be great, and I don't think that should deter you. We have lots of folks that have, well, I'll leave it at that. You should run.
Well, thank you, thank you.
Thank you. Is there any proponent conferee who wants to address the question posed by the senator about why the need for a constitutional amendment on the issue? And if no one wants to address that, that's fine too. Just wanted to make that available. So I know some of our proponents aren't in the room, but yes, Senator Bowser.
Thank you, Madam Chair. I support this bill, and I want to thank the proponents for their testimony today. And I think I know the answer to my question already, but I want to talk to our advisor here and get sort of an expert opinion, if you will. Hypothetically, if the executive branch issued an executive order that, let's say, prohibited me from attending my house of worship on Sunday, would the legislative body be able to review that executive order and potentially override it with the majority?
Madam Chair, Senator Bowser, the words in this proposed constitutional amendment only speak to administrative rules and regulations. So it is silent about anything related to executive orders.
I thought that was the answer. Thank you.
Thank you. Senator Titus.
Thank you, Madam Chair. Mr. Stafford, if you'd come up for a sec. Thank you, Mr. Stafford. My question, you gave some good examples, and I'm certainly sympathetic to the goal of this bill and understand the intent. But I have two questions for you. The first, you gave a couple examples of situations that exceeded the power of regulations where the Attorney General just messed up, right? I think the Attorney General rescinded an approval, which there's some question of the legality in even doing that. But we can't make everybody in the process do their job correctly. But the legislature, as I'm aware in those cases, they have the authority to pass a bill to stop these things. And I'm not aware of, maybe with the Board of Cosmetics once in the last 5 to 10 years, we've seen an attempt to do that. But it seems like the legislature's been unwilling to do the work necessary to actually stop regulations they don't approve of. Could I get a comment on that and how that feeds into why this is necessary?
Sure. Yeah, Madam Chair, Eric Stafford with the Kansas Chamber. So yes, you're correct. And that's in the one of the examples that I gave, where they were then the AG approval was pulled back on a few of those regulations. But I think that goes to show mistakes can be made throughout the process, right? And if those had not have been caught and moved forward, the only path we have, I don't know how, I'm going to kind of blend your question about
It wasn't a
the
very
Board of
clear question
Cosmetology.
either.
No,
My
it was a good
apologies,
question. What power do you guys have to, I don't necessarily think you can pass a bill specific to a regulation that is already in direct conflict with statute. If the statute's already there about the formula for wages on an injured worker and a new formula is passed through regulation, you have to challenge the regulation itself, right? There would be litigation over the legality of those specific regulations. I don't know if passing a bill when you want to go back to the formula that's already in statute, I don't know how you could, how you would fix it, right?
Yeah, it would be, you would either, someone would challenge or a budget proviso to stop enforcement or something. But
Yeah.
your technical point, I think, is fair.
But to Mr. Stuckey's comments, though, I think that ideally, the ideal process is JCAR does have the ability to prevent regulations from passing, because we've sat through, and you mentioned the Board of Cosmetology. I think the day of the two-person crew hearing, there was a Board of Cosmetology fee increase that was proposed when they're already sitting on, I don't know, I think it was like $1.5 million in reserves or something like that. But so the committee was like, well, why are we asking for this fee increase when you already have significant reserves in place? And so, but again, the committee was frustrated because there's nothing that they can do to stop it, because at that point, it's just a procedural stamp of approval and no option to reject.
Other than to pass a bill limiting the amount of fees they could increase, right? I mean,
Yes, and following up too, and I think I've said this on another regulatory bill, maybe not this session, but just words of encouragement, when we grant rule and reg authority in a bill, be a lot more prescriptive on what exactly the authority is you're granting. You know, list out A, B, C, D, and E, or A, B, and maybe C, but just being a little bit more prescriptive on exactly how or what regulations are intended to be implemented in the actual bill versus just we're granting the agency rule and reg authority.
I do agree 100% with that. The other question I would ask, in reading the amendment, it would appear the way it's written that there can be a regulation that is fully within the agency's granted authority, and if legislators just don't like it, for whatever reason, they could revoke or revise it, even though it was within the agency's authority to adopt. Is that correct? Because well, I'll let you answer.
I think you're correct. My guess is the next step would probably be litigation over that. But I, in terms of interpretation of who has the right authority, I think based on your question.
I think it was more of a, that's interesting. I hadn't thought about.
But I think
the
the answer is yes.
Yeah, it was more about guardrails. Is that too broad? Because it can be revoked for anything, even though it's within the scope. But.
Yeah, and two, I do want to say, I mean, oftentimes you hear from conferees about how bad everything is, right? And it's always the negative. And I do want to say, we do have a pretty good regulatory climate, right? The few examples that we've given, that we've seen come up, you know, they are the exception, but they're beyond the scope of what we believe to be legislative intent. But in our view, again, this is, I feel like regulations are, or should be, nonpartisan. You know, oversight of regulation should be nonpartisan, and it's all dependent upon the administration who's in office to protect both sides, right, and protect everybody, because there could be administration that supports some policies that we are supportive of from the chamber's perspective, but then they issue a regulation that we just absolutely despise from, you know, some state agency that we feel strongly goes against legislative intent. It cuts both ways, I guess is my point, that this shouldn't be seen as an attack on Governor Kelly, nor should it be seen as an attack on a future governor or a previous governor. We view it as truly just trying to provide the proper checks and balances between the executive and legislative branch.
Thank you.
Having served on JCAR for a number of years, Mr. Safford, you are correct that I don't know what percentage it is, 95, 99%, or something less, I'm not sure, but most of the rules and regulations that come through that committee for procedural review, sometimes there aren't even questions about them. So, but it's the few that sometimes the committee expresses frustration, not on whether it's proper authority exercised by the executive agency or board, but that it's a policy decision and that policy decisions are to be enacted by the legislature, not by agencies and departments. And I can think of a couple of examples. One was going to require, as a graduation from a Kansas high school, that every student was going to be required to fill out the FAFSA form for college applications. And there was a lot of discussion about that's really a policy decision. Do we want that in rules and regs? And another one was changing the requirement of a crew in a certain industry from 1 to 2 and what that would mean. And so, and then the Board of Cosmetology was another example that instead of, it was something like in our nursing home facilities across the state, instead of 1 sink for each 2 or 3 chairs in the facility, it would be requiring 1 sink for every chair, and the workers' comp was a big one as well. So with the current situation we have, there's those policy decisions are being made at the in the executive branch rather than the legislative branch, and I think that's what HCR 5008 would help address. That the policy decisions would be then be able to be determined by the legislature.
Yeah.
And could you talk about the need or why it's in the proposal that it would be a resolution of the legislature rather than a bill?
To revoke?
Or amend,
Or amend.
yes.
So I probably would have to go back to the drafters of the amendment. We didn't draft the constitutional amendment. We were there to support it when it was introduced. That probably would defer the question to those who drafted it, quite honestly. You know, I would say in response to the policy piece of, you mentioned the 2-person crew one, that led, the reason why we asked for the REINS Act last year is because of the lack of economic impact statement, which that one did actually show an economic impact statement that would have been sufficient to trigger the bill moving through the process for the legislative approval on the regulation, which is how that REINS Act operates. So in terms of resolution versus a bill, I mean, I don't know, and I don't know, Randy's one of our partners that we work very closely with on regulatory reform. The others are down in immigration hearing right now. But I don't know if we would have a difference of opinion if it was a bill. I think that would be just as fine as a resolution, quite honestly. Probably would be a little bit more thorough in the process, I would think. But the reason behind it, I couldn't tell you why they drafted it that way.
Is the reason partly because with a resolution, it's a legislative decision rather than a bill would be subject to a governor approval, and the governor is where the executive department's rule and regulation came from in the first place?
Yeah, that very well could be. I'd feel comfortable, unless Randy has an answer, I'd feel more comfortable asking those who were involved in the drafting as to why it was a resolution versus not a bill. But that very well could be.
Thank you. Any other questions? No. Senator Reichman.
Thank you very much, Madam Chair. And I guess this could come to you, Eric, Ms. Stafford, or it could go to Randy Stuckley. Today, if I'm not mistaken, we're voting on constitutional amendment. I believe that's going to be in August of 26 also, along with this one. Do you see as far as presenting these, having more than one at the same time could cause a problem with the people voting on it or whatever? Because I know Randy Stuckey said that this came up before and was put down, and he thought there was an idea of an oath. So I know maybe you guys aren't in the process of the strategy was on it, but I would still be interested in your input on it. Thank you.
Yeah, Madam Chair, Eric Stafford again with the Kansas Chamber. Good question, Senator Reichman. Yeah, I mean, I think there's concern out there, but I think the number of amendments that are being discussed or talked about right now, I mean, you can do 5 in an election, I think, is what we allow for in the state, 5 per election, so, or up to 5. I think the number of those that are being considered right now, I think you're okay. I mean, it's the will of the people, and to Randy's point earlier about, you know, 2022, there was just an entire plethora of bumper stickers that said vote no, right? So it was just a vote no on everything. You know, understand that, but again, I think it gave us hope that this was, you know, 8,000 votes away. But again, I go back to the fact that we're one of roughly a dozen states that currently have 0 legislative oversight on our rule and reg process. So, you know, willing to take that chance. But that's the beauty of our constitutional republic and allowing people to vote. You know, we don't have ballot initiatives in the state, so we have to go through constitutional amendment through the legislative process. And I think that's the safest strategy.
Thank you. Senator Rose.
Thank you, Madam Chair. I'm of the opinion that when we put an amendment on the ballot, the simpler and clearer the statement is, the better. And in looking at the explanatory statement, it's comprised right now of 2 sentences, and in my opinion, they say the exact same thing. It's redundant. Would it be possible for us to just use the second sentence on the ballot, which would say, this amendment allows the people's representatives and senators to revise or revoke rules and regulations that are unnecessary, burdensome, or otherwise not beneficial to the public good? Very clear, very concise, says the exact same thing as the first sentence.
I would, Madam Chair.
That may be a
Stafford with the Kansas
revisor.
Chamber. Yeah, revisor question, but I'd also probably view that as a House-Senate Conference Committee conversation where you guys can negotiate the differences. So I will respectfully punt, and if you feel like it's a good idea, then that's the will of the committee. So again, you know, we weren't responsible for the base amendment. We weren't responsible for the amendment either. But I will say to Senator Reichman's question, that was partially driving the concern over the original amendment, in the sense if there are going to be multiple amendments, you could have a 8-page ballot full of constitutional amendments, and they were trying to find a way to condense it, is my understanding as to why it was changed. So, but we weren't involved in those conversations.
Thank you. Other questions? Not seeing any. Thank you for your testimony and for the answers today. Is there, I thought that there was proponents outside of the room when we were talking about a resolution versus a bill. Is there anyone who wants to speak towards that question? Please reintroduce yourself. Thank you.
Thank you. Jim Manley, State Policy Chief, Pacific Legal Foundation. The legislature currently has the authority to pass a bill revoking any or revising any regulatory grant of authority or any specific regulation. So I think the innovation and the genius of the concurrent resolution is that it allows that decision to be made by the legislature alone without the needing the approval of the governor.
Thank you. I didn't see any other questions, so we'll ask for, are there any persons wishing to testify neutral or opponent on the resolution? Not seeing any. Then we will, yes, Senator Haley wishes to testify, as I'm not sure, but
No, a question. But
yes,
thank you,
okay,
Madam
go ahead.
Chair. Not on this one, but I did note in the subnote that in the House, there was opponent testimony offered by ACLU and 6 private citizens have we not received. So apparently there's been none received here, and perhaps they've withdrawn their opposition or otherwise have just not weighed in.
Correct, we didn't receive any timely testimony, so we didn't have that.
All right, thank you, Madam Chair.
Thank you. Committee, we didn't have any other questions and no neutral or opponent conferees, so we will close the hearing on House Concurrent Resolution 5008. Thank you to all our conferees and to those following along. We do have a few minutes to work a couple of bills. I want to start with the 2 that we heard just yesterday, so they'll be fresh in our memories. One would be House Bill 2371, and a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2371 amends the acts relevant to the limited liability licensure and registration and makes those changes related to Series LLC.
Is there any discussion? I do want to change the effective date from publication in the statute book to the register. And I'll just make that a conceptual motion if no one objects to the conceptual aspect of it rather than being written. And would there be a second on it? Senator Rose. So I'm not seeing any discussion, and I'll close then. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill as amended. Is there any further discussion or a motion? Yes, Senator Titus.
Thank you, Madam Chair. I would move that the committee recommend favorably for passage House Bill 2371 as amended.
Thank you. Is there a second? Senator Clays. Any discussion? Not seeing any. Then you want to close? Thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you. The second bill we heard yesterday was House Bill 2212 regarding increasing the reimbursement amount that the Secretary of Corrections may make to inmates. Go ahead, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2212 was the bill you heard about the claims process, increasing the value of the claims that the Secretary can resolve on their own before they come to the Joint Claims Committee.
Thank you. Any questions for the reviser? Senator Haley? No, no questions for the reviser. Any discussion? Or Senator Haley?
Or motion.
Or a motion. I'm thinking about changing the effective date to send it to conference, if that's want to be your motion, and we can join it with then pass it out as amended.
With the chair's consent, I would move that we change the effective date of 2212 to the registry, and that we then, as amended, pass the bill favorably.
And we have a second, and there's no objections to the conceptual and combining the two motions. Not seeing any. Then you all have heard the motion. All those in favor? The second was Senator Clays. Sorry. Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. I next wanted to work a bill that we talked about yesterday, House Bill 2166, and that's continuing KORA exceptions in statute. And there were 2 exceptions that were being continued, and we had some discussion on that, so I thought we'd lay it over another day, and if we could have a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2166 is the annual review of the exceptions to KORA that are expiring. There were those 2 exceptions that you put in place in 2020 that are now going to expire unless you take action. So this bill would continue those into existence.
Any questions for the reviser? All right, any Yes, a question. Yes, Senator Shane.
Thank you, Madam Chair. I was just going to comment. I know that I had brought up some points of discussion, but I think we determined that my questions would be better addressed potentially through a separate bill. So I will not be bringing forward any suggested changes to the current proposal.
Thank you for your consideration and for that discussion, and maybe we'll be seeing a different bill on that. So thank you. Any further discussion? Not seeing any. Senator Titus.
Thank you, Madam Chair. I move that the committee recommend favorably for passage House Bill 2166 and place it on the consent agenda.
Is there a second? Senator Rose. Any discussion? Not seeing any. Do you want to close? Thank you. You all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Then committee, we had actually, I guess it was a third bill regarding CORA this session that we've heard here, and that one would be House Bill 2134. And a brief summary from the reviser. 2134.
Thank you, Madam Chair. House Bill 2134 makes some changes to CORA, specifically with how the charges for obtaining those records and how those fees can be determined and given to the person requesting the records.
Thank you. Any questions for the reviser? Senator Bowser.
Thank you, Madam Chair. I had a note here to myself. We wanted to make sure that SB 70 and this bill didn't contradict each other. Have we made that determination?
Well, if there are differences, those can be resolved in conference, but we're free to amend this today if that's the will of the body. And they do have some differences, Ms. Scott, if you wanted to address those, but.
Sure, thank you, Madam Chair. The Senate Bill 70 changes that you made with respect to fees are pretty small. You left that 25-cent per page fee, and then you said that no fee can be charged for electronic records. Some really minor changes. This bill really changes how those fees are determined. So probably once they get to conference, you'd want to take a look at those and decide policy-wise how you want to handle that.
Thank you. Other questions for the reviser? All right, then discussion. Senator Titus.
Thank you, Madam Chair. I have an amendment. If you pass out the itemized list, Chris. And just to Senator Bowser's point, I agree. There is good language in this bill, and I'm going to propose a change. If it gets adopted, that'll, I think, put it all on the table, and there's a bigger discussion to be had and approach on this. So while the reviser is passing this out, I'll explain the bill. You'll see on the back page, I'm sorry, the amendment on the back page. What I'm suggesting we put in is, like I said, I think this language about reasonable efforts and actual costs is good, but to me, the public knowing what they're being charged for and what's on the table is the most important part of these bills. And I would like to put in language that upon request, if you're requesting records, when you get them and the bill for your fees, you can request an itemized list from the city. And I list out some of the particulars. It would include the hourly rates charged and any other fees. I think if you just get a lump sum bill and you have to fight to find out what those charges are, I'm assuming some entities would do this anyway. But your only recourse if you don't like your situation is to make a complaint to the Attorney General's office. That requires a month-long investigation. And basically you're cut out from getting your records without paying large fees. I did shop this with the League of Municipalities. They were concerned that if they had to provide an itemized list, it might cause too many disputes. They think that just requiring reasonable cooperation is enough. I respectfully disagree with that position, and I'd like the public to know what they're being charged for. So, but I did want you to know that some of the proponents did not necessarily like this language, but I think it's good public policy and improves accessibility. So I would offer the amendment and stand for any questions.
Is there a second? Senator Clays. Any discussion? Senator Shane.
Thank you, Madam Chair. Question for Senator Titus, if I may. Would you envision this being prior to, so upon initial request, they would provide an itemized estimation, or this would be kind of a post hoc. You need to demonstrate that you actually incurred the number of hours that you thought you might incur and attribute the hourly wage to. I guess functionally, I'm just trying to understand how this might work for a citizen.
Senator Titus.
Thank you, Madam Chair. Senator Shane, when I wrote this, I was envisioning an after-the-fact request. They are required to provide you an estimate, and that's going to be lump sum. I think this would allow you, this doesn't preclude you from asking for, well, how many hours did you include in that estimate at what rate? But that's not necessarily what I had in mind. It was more after the fact to make sure everything they've done is reasonable.
Senator Shane.
Do you think this would help address the potential of an entity estimates it's going to cost $500 to fulfill this request, and then in actuality, it does not take as long as they thought, but they still assess the $500 because that's what they initially said? Do you think that that helps alleviate where they would come in at less than the $500 if they actually incurred less cost? Or
Senator Titus.
Thank you, Madam Chair. Senator Shane, I think it moves the needle on that issue because what we'll see is, depending on the complexity of the request, we'll be able to see the hours and who they had to do the research, and it'll just make it much more clear, was this reasonable or not? I don't think it's a perfect solution, but I also don't want to put so many requirements on this that it ends up tanking the bill in its entirety.
Senator Shane.
Thank you. I agree with the sentiment, and I would support the amendment.
Does it help that the amendment says statement of costs incurred by the public agency and charged to such requester? Does that envision that it's at the conclusion of the work done rather than at the front end?
And yes, and
Senator Titus.
I think it's easier when you pair it with the language in this bill about them only being able to charge actual costs now. I think it pairs with that a little and works a little bit better. The system we have now with the different fees and things is a little clunky. So I think in the whole, this will make for a much better system.
Would it be helpful if we added actual costs to the balloon, or is that confusing things too much? Senator Titus.
I don't have a strong opinion either way.
Is that, well, we can leave it as it is, and we'll go from there. So Senator Bowser.
Yes, thank you, Madam Chair. I'm just going to say I support this amendment because it provides transparency. I applaud Senator Titus for bringing this forward.
Senator Corson.
Thank you, Madam Chair. This is probably elsewhere in the bill, but if somebody makes this request, they get the information that's described in the amendment, and they feel like it sort of proves that maybe in their mind something was amiss or something was inappropriate or a charge was excessive. What is their recourse? Is it still just going to the Attorney General, and or does the bill elsewhere provide any kind of recourse if you do get this information and you think it actually does in fact show that maybe something was amiss? What's your recourse as a citizen?
Ms. Scott, if you can.
I would, thank you, Madam Chair, Senator Corson. I would have to look at some of the other statutes in the Act to be sure about that. Certainly you could go to the Attorney General as like a violation, to report a violation of the Act, but I'd have to look at some of the other statutes, and Senator Titus might know the answer to that also.
Thank you. Senator Titus.
Thank you, Madam Chair. Senator Corson, I don't believe there would be any other recourse. The thought is just, at least to start with something, having to show your work very clearly on the front end. Once you have to justify that, hopefully it alleviates the need to go to the next level when everything's sort of, the cards are all on the table on the front end rather than after the Attorney General looks at it.
Senator Corson.
No, that's a helpful answer. I appreciate that. Thank you. Thank you both.
Thank you. Further discussion? Not seeing any, then did you want to close, Senator Titus?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion appears to carry. The motion does carry. Does anyone want to be recorded as a no? All right then. We are back on the bill as amended. Any further discussion or motion? Yes, Senator Titus.
Thank you, Madam Chair. I move the committee recommend favorably for passage House Bill 2134 as amended.
Is there a second? Senator Shane. And any discussion? Yes, Senator Argabright.
Thank you, Madam Chair. I just, from one of the Register of Deeds, I found it interesting that one of their biggest challenges is not their local people on this topic. It's out-of-state inquiries that do require a lot of time. So I just passing that information on. So thank you, Madam Chair.
Thank you. Committee, other discussion? Senator Shane.
Thank you, Madam Chair. Senator Argabright, to that point, I believe there is going to be a compromise amendment offered on the House side for SB 70 to help address the concerns of the registers of deeds.
Thank you. Other discussion? Not seeing any. Senator Titus, did you want to close on your motion?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. The last one I would like to take a look at today is House Bill 2183, and that is the bill that addresses artificial intelligence and children and sexually explicit material. But a bill briefly from the reviser.
Thank you, Madam Chair. House Bill 2183 changes the definitions and some of the elements in 3 crimes: sexual exploitation of a child, unlawful transmission of a visual depiction of a child, and breach of privacy to cover those artificially or those images that are changed using artificial intelligence.
Any questions for the reviser? Not seeing any. Any discussion? I do have one amendment. And it adds to, on page 6 of the bill, in addition to exempting out a cable service, it would also, upon request of industry providers, would exempt out direct-to-home satellite services and a multi-channel video programming distributor. So with that, is there a second to add them in the bill? Yes, Senator Rose, thank you. Any discussion or questions for the reviser if I haven't explained it very well? Senator Bowser.
Thank you, Madam Chair. I've got a question for the reviser. Again, so we use the word obscene here. Do we need a definition of obscenity?
Madam Chair, so obscene is defined, actually, let me get the page number for you. It's on page 3 of the bill. We're adding that new definition. It looks new, but that is a definition that's used in other statutes, for example, promoting obscenity to minors.
Thank you, that answers my question.
Thank you. Senator Schmidt.
Thank you, Madam Chair. And I just want to make sure I'm understanding the amendment that you're pointing to on line 42. How would that impact like popular online messaging boards, or how would they be impacted by this law for the state of Kansas? I really don't know, so I'm trying to think about it too.
Sure, and does the reviser want to take a reply at that? Thank you.
Sure. Thank you, Madam Chair. Senator Schmidt, I'll try to put the definition in a little bit more context. So this is going into the crime of breach of privacy. So that's this scenario that you guys were talking about when you have an adult who is taking an image of another adult who had an expectation of privacy when that image was taken, and then they're disseminating that to someone else. There's a provision in here that says this crime doesn't apply to these types of people: an operator of a switchboard, a provider of an interactive computer service. The House added a cable service, and this is just adding 2 more of those. So essentially, a provider of direct-to-home satellite services can't be prosecuted of the crime of breach of privacy because someone posted a picture on their service that they're providing.
Yes, Senator Schmidt.
So I guess my understanding is that there are some popular message boards like 4chan or Reddit where we've had this problem, whether it's teens or adults. And I guess I'm just wondering, I really don't know, I don't have an agenda, but I'm just wondering if it's in our interest, or if we're executing the intent of this legislation, if we're exempting those hosting services from this law. And I'd turn it over to you if you have any thoughts.
Thank you. This was presented from the industry, and I don't see a representative here, but for the exemption number 7, a multi-channel video programming distributor, is that, can you give us an example of that as it's defined in the U.S. code?
Madam Chair, let me...
It's the same statute, but a subsection of what's a cable service. So I think the intent is that the provider, the carrier, wouldn't be held liable for the content that's on the provider service, if I have that right. I'm not sure, Ms. Scott.
Madam Chair, I can read you what that definition is, how it's defined in the code there. It's a person such as, but not limited to, a cable operator, multi-channel, multi-point distribution service, direct broadcast satellite service, or a television receive-only service. So the way I'm reading that is more like a satellite provider or a TV cable provider, not those internet providers. But there is on line 36 already in current law the interactive computer service. I'd have to look at the definition there to see whether the service providers that Senator Schmidt is talking about are already kind of exempted out here.
So we didn't have testimony about this, so anyway, the questions have been presented. So is there further discussion on the amendment? Yes, Senator Shane.
Thank you, Madam Chair. I think to help address Senator Schmidt's question, I believe what he's looking for would maybe be exemption to a provider of an interactive computer service, which is where I believe non-publishing social media and messaging channels would fall. So that'd be Facebook, Reddit, 4chan, what have you. And that would all fall under anything that falls under 47 U.S.C. 230.
Thank you for that. And so this is just the other providers, like a cable service provider, and not the peer-to-peer contact like a Reddit is, I think, the distinction here, if I'm getting that correct, Ms. Scott.
Yeah, Madam Chair, that's why I mentioned that, because I think that the types of service providers that Senator Schmidt is talking about are already covered under current law. They're not addressed in the amendment.
Okay, thank you. And so the amendment doesn't address those peer-to-peer services.
I don't believe so.
Okay, it doesn't. Okay, yes, Senator Schmidt.
I'll do some more research, and if I have further concerns, maybe we'll talk with you, and something we could work out on the floor if it comes to that.
Sure, thank you. Is there further discussion on the amendment? Not seeing any, then we did have a second. So with that, then I'll close, and you all have heard the motion. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. We're back on the bill as amended. Any further discussion? Is there a motion? Senator Corson.
Thank you, Madam Chair. I think as a whole, this bill provides really important protections for folks in this new technological age that we're all living through. So I would move that the Senate bill pass, that the Senate Judiciary Committee pass Senate Bill 2183 as amended favorably.
Thank you. Is there a second? Senator Bowser. Any discussion? You want to close?
I would close, Madam Chair.
Thank you. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. And with that, then, our work for today, with many thanks for everyone who has participated today included, and our meeting is adjourned.